Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Hey, just me today. Today I'm going to bring you the third part in our three-part release of The Queen and Grant. If you want to listen to the majority or Justice Binney's concurring decision, you can head back to the previous episode. I'm about to read you the English version of the reasons delivered by Justice Deschamps. Hope you enjoy. The difficulty in resolving the problems related to detention and to the exclusion of evidence in 3 appeals now before the court reveals a number of deficiencies in the applicable rules. These 3 cases show that it is sometimes hard to reconcile the protection of constitutional rights with the public interest in bringing cases to trial. I have read the reasons of the majority, and I agree with them that the tests for determining whether a person was actually detained and whether evidence should be excluded need to be reformulated. With respect, however, I must comment further on the application of the new rules concerning detention to the facts of this case. As for the factors to consider in deciding whether to admit or exclude evidence obtained in violation of constitutional rights, I find that the test proposed by the majority is problematic, and that it is inconsistent with the purpose of the constitutional provision that applies to such decisions. Although my analysis differs from the majority's, I reach the same conclusion as them. Part 1. Test for determining whether a person was detained. Where the state interacts with citizens in a criminal law context, be it in the streets or in a courtroom, the applicable rules must be clear so that all those involved in the criminal justice system know the scope of their respective rights and powers. I agree with the majority that the police cannot do their work effectively without the cooperation of the public. The applicable rules must therefore take into account the fact that the police need to act so as to foster public cooperation, not to discourage it. In the instant case, the trial judge stressed the fact that the police officers, who were patrolling an area around 4 schools where numerous disturbances had been reported, had conducted themselves politely and seemed to have been conscientious in doing their work. On whether the law prohibits or should prohibit this type of police action, the trial judge quoted with approval the following comment by one of his colleagues. Quote, "We do not expect the police to sit in their station houses waiting for those who commit offenses to walk in and confess. We expect them to be out in the community, and when suspicious events occur, to make inquiries. The charter is not a barrier to those inquiries." End quote. This approach is the very one on which the majority of this court are basing the test adopted today to guide the public, law enforcement agencies, and judges in determining at which point a person is detained in the legal sense of this term. In the companion case of the Queen and Subaru, the majority of the court acknowledge that police officers may interact with the public, and that not every contact between a police officer and a member of the public constitutes detention. There is a clear distinction between the nature of the police action in the case at bar and that of the action in Subaru. Subaru concerns a targeted action by officers who had received specific information. In the case at bar, the action was one of prevention, and the officer's approach was necessarily different. It will be helpful to consider the trial judge's findings of fact. Constables Worrell and Ford were on patrol in plain clothes in an unmarked car in an area where 4 high schools are located. The area was experiencing problems related to intimidation, robberies, and drug offenses involving students. The 2 officers had been ordered to maintain a presence there for purposes of prevention. They drove past an individual, Mr. Grant, and noted that he was staring at them. After they had passed him, Constable Worrell turned around and saw that he was still watching them and that he was fidgeting with his clothes and his waist and pulling on his pants with his right hand. At this point, the officers felt that it would be appropriate to speak with him. As they continued along their way, they saw another officer, Constable Gomez, who was on patrol in a marked cruiser. They suggested that he go speak with Mr. Grant, which he did. While speaking with Constable Gomez, Mr. Grant behaved nervously and touched his clothes at his waist, which prompted Constable Gomez to ask him to keep his hands in front of him. At first, Constables Worrell and Ford stayed apart from Mr. Grant and Constable Gomez, but on seeing that Mr. Grant still appeared nervous and continued to look at them, they decided to move closer and make sure everything was all right. They identified themselves, showing their badges, and then stood behind Constable Gomez. I will not repeat the exchange that took place between Constable Gomez and Mr. Grant. The relevant passages are reproduced in the majority's reasons. All I need to say here is that Mr. Grant made an incriminating statement. In analyzing all these facts, the trial judge found that Mr. Grant had not been detained. The following is his own lengthy summary of his reasons for so finding. 1. The location being the sidewalk of the main street in the city of Toronto in full view of the public. 2. The means by which the police spoke to the accused, i.e. on the street, and the accused not being required to stay or get into any vehicle or closed type of situation. 3. The time of day. It was broad daylight. It was approximately 12:30 p.m., the usual noon hour for students. 4. There was no physical force. There was no pat-down search and there was no grabbing, where someone, especially the accused, in any situation might feel intimidated. 5. There was no actual search or physical search, of course. There was just some questions put. 6. There was an absence of reasonable and probable grounds to conduct an arrest, and there was no reason to take physical control of the accused until, of course, the marijuana and firearms surfaced. 7. What would Police Constable Gomez have done if the accused, for example, left the scene? He may have followed him. He may have asked him further questions. There again, that is the subject of speculation. 8. The length of the interaction. It was short. It consisted of minutes. This was not a 1/2 hour or hour interrogation. It wasn't off the street or in a police cruiser. 9. The response of the other police officers. These officers stood behind Gomez, but they were not involved in the discussion. They didn't surround the accused, nor did they detain him, and I may address that issue further in due course. 10. The nature of the conversation with Gomez. It was not in aggressive language. There were no demands or directions. The only request was that he keep his hands in front of him. There was no demand to enter a cruiser, and nothing was said that I find would be compelling. There were no threats or inducements. The officer just asked some general questions, and in response to those questions, the accused produced identification as to who he was, where he lived, and he even gave his phone number. 11. The accused could have walked away. He could have walked around the one police officer or the 3 police officers and could have kept going. All he had to do, in my view, was say, "Excuse me." To suggest for one moment that he couldn't or they wouldn't permit it is speculation. There was no evidence that the accused felt compelled or had a subjective belief in relation to anything. The inference is that the accused decided to cooperate all the way with the police. The quantity of time spent was referred to. I conclude very easily that this was a conversation of an extremely short duration, lasting no more than several moments, but no more than 3 or 4 minutes. So much so that I find the ultimate crime, the solving of the crime and the arrest and search incidental to arrest, took some 4 minutes or less. I also find that the limited conversation between Police Constable Gomez and the accused was no more than that, a conversation and an attempt to chit-chat or make chit-chat. Here again, I find it was all meant to check on the temperature of the community. Unlike the trial judge, the Court of Appeal concluded that Mr. Grant had been detained. I agree with this conclusion. Viewed as a whole, the facts support the conclusion that there was indeed a detention. However, I wish to point out that the detention came to a head when the officers asked Mr. Grant certain direct questions that, viewed objectively, might have caused a reasonable person to feel singled out, cornered, and therefore detained. Owing to the nature of the questions asked by Constable Gomez, the line between prevention and suppression was crossed. Constable Gomez asked Mr. Grant if he had committed a crime. Once such a question had been asked of a person who had known he was being watched from the time he had crossed paths with Constables Worrell and Ford, who had since arrived on the scene, The encounter could no longer be described simply as an interaction between a police officer and a member of the public. I agree with the Court of Appeal's conclusion that the exchange was no longer an impromptu conversation that a young man such as Mr. Grant would think he could walk away from as he pleased. In light of the conclusion that Mr. Grant was detained, I must consider the power of police to detain a person for investigation purposes in performing their crime prevention function. Unlike in the context of crime suppression, police officers who are charged with preventing crime, in particular, as in the instant case, in an area near schools experiencing problems related to violence, know that unlawful acts have been or will be committed, but do not know when, where, or by whom a specific crime will be committed. They must therefore have some leeway to be able to perform this function adequately. Although I cannot conclude that the officers in the case at bar had a reasonable suspicion that an offense had been committed, I would not want what is said in this judgment to discourage them from intervening. As can be seen from the trial judge's reasons, the officers were calm and polite. Even though their actions may, viewed objectively, have constituted detention, that was most likely not intentional. It would therefore be best in future for police officers to avoid asking incriminating questions of people who are likely to be viewed as suspects. The direct questions in the instant can be compared with the circumspect approach taken by officers in the Queen and Kang Brown. If, in the course of an exchange of words in which officers act circumspectly, the behavior of the person they are speaking with changes, the next question is whether the facts are sufficient to give rise to a reasonable suspicion that an offense has been or will be committed. If they are sufficient, it will then be open to the officers to exercise their power of investigative detention. In short, I believe it is important to educate the police about how their conduct affects members of the public. If they do not really intend to detain a person, they should, by their deeds and their words, let the person know that he or she is not being singled out. Part 2. Factors supporting the admission or exclusion of evidence obtained in violation of the Charter. The majority propose revising the test developed in the Queen and Collins for admitting or excluding evidence obtained in violation of a right protected by the Canadian Charter of Rights and Freedoms. I agree with them that the test needs to be revised, but in my view, the formulation they propose is inconsistent with the purpose of Section 24(2). I will be proposing a simpler rule that focuses the analysis on two aspects: the societal interest in protecting constitutional rights and the societal interest in the adjudication of the case on its merits. On the basis of these two aspects, it will be possible to consider all the relevant circumstances in order to determine whether the exclusion or admission of the evidence would bring the administration of justice into disrepute. Subpart A. Purpose of Section 24(2) of the Charter. The identification of the purpose of Section 24(2) of the Charter is of prime importance for the determination of the factors to be considered in applying this provision. According to Professor David M. Paciocco, quote, recent experience in the United States has demonstrated that the vitality of the exclusionary rule depends entirely on the purposes that are identified for exclusion. This is because each of the rationales has its own level of vulnerability and its own sphere of operation, end quote. However, Professor Kent Roach cautions that, quote, if none of the approaches is in a preferred position, the choice of which rationale will prevail in a particular case is likely to be inconsistent and results-oriented, end quote. Collins had the merit of setting out the first test for applying Section 24(2). But neither in that case nor in those that followed can the court be said to have identified a guiding principle or taken a clear position ranking the various purposes that are often cited for the provision and can be drawn, sometimes implicitly and sometimes explicitly, from the case law. The failure to do so is surprising, given the importance the court has attached to contextual analysis and to the need, in interpreting any provision, to consider its purpose. I accordingly agree with the majority that the purpose of Section 24.2 of the Charter is found in the words of the provision. Section 24 reads as follows. 24.1. Anyone whose rights or freedoms, as guaranteed by this Charter, have been infringed or denied, may apply to a court of competent jurisdiction to obtain such a remedy as the court considers appropriate and just in the circumstances. 24.2. Where, in proceedings under subsection 1, a court concludes that evidence was obtained in a manner that infringed or denied any rights or freedoms guaranteed by this Charter, the evidence shall be excluded if it is established that, having regard to all the circumstances, the admission of it in the proceedings would bring the administration of justice into disrepute. The purpose of Section 24.2 is to maintain public confidence in the administration of justice. Since this purpose is a general one, it makes it possible to take the various functions of the criminal justice system into account. This purpose also makes it possible to identify a common denominator between Sections 24.1 and 2. It is clear that one of the purposes of the remedy provided for in Section 24.1, more specifically a stay of proceedings for abuse of process, is to maintain the repute of the administration of justice. Although a stay of proceedings can be granted only in the clearest of cases because it allows the accused to go free, the comparison with Section 24.2 is not without interest, especially in a case where the exclusion of evidence would in practice lead to the discharge of the accused by resulting in his or her acquittal. A court that must decide under Section 24.1 whether to order a stay of proceedings may consider the balance between the public interest in having all charges dealt with on their merits and the public interest in having all charges stayed to show the court's determination to ensure the continued vigor of checks and balances in the criminal justice system. This balancing exercise is also essential to the analysis required by Section 24.2. Under Section 24.2, the judge must decide whether the best way to maintain the repute of the administration of justice would be to admit the evidence or to exclude it. I also agree with the majority's proposition that the exclusionary rule has, primarily, a prospective societal role in that the judge's analysis must focus on systemic concerns. The court cannot consider the case of the accused person who is on trial without addressing the long-term impact of its decision on the administration of justice in general. If, where the stay of proceedings and the admission or exclusion of evidence are concerned, the point of convergence between the first and second subsections of Section 24 is the balancing of two factors, what distinguishes these provisions is that the purpose of the first is to provide for an individual remedy, whereas the ultimate purpose of the second lies in the societal interest in maintaining public confidence in the administration of justice. The first is focused on the individual, the second on society. The statement that Section 24.2 has a long-term societal purpose is of great significance for the identification of the factors to be considered in the analysis. In my view, the test proposed by the majority, by focusing the analysis on the conduct of the police in the first branch and on the interest of the accused in the second, and by attaching less importance to the seriousness of the offense in the third, does not give sufficient consideration to the long-term societal interest that must guide the judge in reaching a decision. Subpart B, the test, branches and factors. Since Collins, the courts have generally applied a test under which the factors relevant to the analysis to be conducted in applying Section 24.2 were grouped in three broad branches. This court has applied this test in many subsequent decisions, including the Queen and Greff, in which Justice Lemaire summarized the test as follows. Quote, the first set of factors are those relevant to the fairness of the trial. The second set of factors concerns the seriousness of the charter violations as defined by the conduct of the law enforcement authorities. The third set of factors recognizes the possibility that the administration of justice could be brought into disrepute by excluding the evidence despite the fact that it was obtained in a manner that infringed the charter. End quote. First, the courts had to determine the nature of the evidence obtained in violation of the rights of the accused. Where real evidence was adduced, admitting it rarely led to a finding that trial fairness had been impaired. Second, they had to assess the seriousness of the violation in light of both the interests protected by the infringed right and the state conduct. Third, the courts considered the consequences of excluding the evidence and determined more specifically whether the evidence was essential, having regard to the seriousness of the offense. In the case at bar, the majority proposed to reformulate the test. The new version continues to have 3 branches: a review of the state conduct, the impact of the violation on the charter-protected interests, and the public interest in adjudication on the merits. It is appropriate that trial fairness is no longer a cornerstone of the test. One of the problems with the reliance on trial fairness in the first branch of the Collins test was that it is a concept with several possible meanings and can accordingly lead to confusion. Trial fairness is sometimes defined narrowly and sometimes more broadly. Defined narrowly, it concerns solely the reliability of the evidence. More broadly, trial fairness corresponds to courtroom fairness. In the latter sense, fairness is related to the concept of conscriptive evidence. Its purpose is to safeguard certain fundamental rights of the accused at trial, such as the right against self-incrimination. This interpretation is essentially the same as the one in the Queen and Stillman. Finally, trial fairness has been defined very broadly by certain commentators and in certain judgments. According to this approach, any use of evidence obtained in violation of constitutional rights is, regardless of the quality of the evidence, reliable, conscriptive, derivative, etc., a breach of trial fairness. It is clear that, although the concept of fairness seems to go hand in hand with any system of justice worthy of that name, it is not precise enough to serve as a reliable guide. The reformulation of the first of the criteria from Collins, so as to exclude the trial fairness concept and take charter-protected interests into account in the second branch of the new test, is a refinement that may help judges refer to concrete and objective factors. I am in complete agreement that the greater the impact of the violation on the charter-protected interests, the more likely it is that there will be negative consequences for public confidence in the administration of justice. For example, interference with bodily integrity and a search of a rented car will not have the same impact on the confidence an objective person with good knowledge of the circumstances of the case will have in the administration of justice. However, I cannot agree with focusing the analysis on the accused, as the purpose remains at all times to maintain public confidence in the administration of justice in the long term, and what is important is the public interest in the protection of constitutional rights. Nor can I accept that one of the factors, state conduct, formally taken into account when analyzing the seriousness of a violation is now a separate branch of the test. In pursuing the purpose of maintaining confidence in the administration of justice, the courts must disassociate themselves from violations of protected rights, regardless of whether or not they were intentional. Although state conduct is of course the source of the violation, it is but one of the factors to be considered in analyzing the impact of the violation on charter-protected interests. I find the majority's emphasis on state conduct puzzling in view of the purpose of Section 24.2. Although the majority acknowledge that the purpose of the Section 24.2 rule is neither to punish the police officers nor to compensate the accused, the importance they attach to this factor places the judge on a slippery slope. Since any distinction between the role of the exclusion of evidence as a way for a court to disassociate itself from a violation and its role as a deterrent, which has been sharply criticized, will be a final one, I wonder what role this factor will actually play. The court's attitude in this respect has already been criticized as being one of doublespeak. I fear that the same word will also be used to refer to the new test. Moreover, by making state conduct a separate branch of the test, the court is drawing closer to the rules applied in the United States, which are based on very different constitutional provisions and a very different socio-political context. It might have been thought that the courts would over time have understood that it is unhelpful to begin the constitutional analysis by considering state conduct. The main problem with the importance attached to this factor is that the deterrent effect of the exclusion of evidence has never been proved empirically. In the United States, many commentators have attempted to demonstrate that the exclusionary rule is either effective or ineffective as a deterrent, and the question is still open to debate. The question has also been the subject of debate in Canada. According to Pacheco, Section 24(2) cannot have a deterrent effect because it does not establish a clear and predictable rule requiring the exclusion of evidence. To other commentators, from the perspective of the conduct of state agents, exclusion is not an effective sanction. The police certainly have an interest in the conviction of an accused, but that interest is above all one of society as a whole. Administrative or disciplinary measures may have a greater deterrent effect on the police. In my view, the reservations expressed regarding the effectiveness of the exclusion of evidence as a deterrent are an invitation to be very prudent as regards to the importance attached to state conduct. Furthermore, a parallel can be drawn with the order for a stay of proceedings for abuse of process, which also has its public purpose the maintenance of public confidence in the administration of justice. As the court pointed out in Canada, Minister of Citizenship and Immigration, and Tobias, the purpose of such an order is not to punish state misconduct. In my view, there is no justification for attributing this role, even indirectly, to Section 24(2). Although I agree that the exclusion of evidence may have a deterrent effect, I do not think state conduct should be considered separately in the determination of what must be done to maintain public confidence in the administration of justice. If a judge must decide whether to admit or exclude evidence, a violation of rights must already have been proved. It is therefore the impact of the violation that needs to be examined, not the inherent seriousness of the state conduct. In sum, I agree with incorporating into the assessment of the impact of the violation a broader perspective according to which all charter-protected interests are taken into account. However, this new approach should be focused not on the accused, but on the public interest in the protection of constitutional rights. Moreover, even though this approach may permit the courts to examine state conduct in order to determine its impact on the protected interests and, if necessary, to disassociate themselves from it, the purpose being pursued is to maintain public confidence in the administration of justice. The need for the courts to disassociate themselves from state conduct is at most one factor to be considered in relation to the overall purpose. Furthermore, in applying the Collins test, the courts have considered both state conduct and the seriousness of the infringement of the interests protected by the violated right in their review of the seriousness of the violation. In my view, therefore, the proposed change incorporates into the test a branch that is in itself inconsistent with the purpose of the provision, and that does not make the rule any clearer or easier to apply. I accordingly find that the objective of the reformulation has not been achieved. At the third stage of the Collins analysis, the judge had to determine the effect that excluding the evidence would have on the repute of the administration of justice. The third branch of the new test, proposed by the majority, requires the judge to assess the public interest in an adjudication on the merits. Although this formulation is clearly broad enough that it will be possible to consider the factors formally regarded as important in the third branch of the Collins test, certain factors are unduly de-emphasized or simply disregarded in the new test. In this regard, the majority's position on the seriousness of the offense being prosecuted is ambiguous. Although the majority described this factor as a valid consideration, they mention that it has the potential to cut both ways, that is, in favor of either excluding or admitting evidence. Their justification for this position is that although the public has a heightened interest in an adjudication on the merits where the crime is a serious one, it also has a heightened interest in having a justice system that is above reproach, particularly where the penal stakes for the accused are so high. I note that they also consider the heightened interest of the accused in having a justice system that is above reproach, especially where the crime with which he or she is charged is a serious one. These comments by the majority help me put the problem in context, and they suggest that the interest of the accused is equal to that of society where the charge is serious. In addition to my doubts about how the seriousness of the offense actually fits into the majority's test, I must say that I disagree with the proposition that in the analysis relating to the maintenance of the repute of the administration of justice, this factor is neutral. First of all, the third branch of the majority's test requires the judge to consider the factors that weigh in favor of or against proceeding to trial. At first glance, it is hard to imagine how the seriousness of the offense, and even the harshness of the sentence, could weigh against proceeding to trial. However, it is conceivable that when the factor of the seriousness of the offense is combined with other circumstances, where, for example, the evidence is unreliable, the accused might claim to have a greater interest in not standing trial if he or she could face a harsher sentence owing to the seriousness of the charge. But this interest is subsumed in the public's interest, which is of course opposed to having an accused convicted on the basis of unreliable evidence. Moreover, a well-informed person who is objective and apprised of all of the circumstances would surely be shocked if unreliable evidence were used in any criminal trial. What the majority suggest is in reality that, on the one hand, the interest of the accused in having the evidence excluded increases with the seriousness of the offense and the harshness of the potential sentence, and on the other hand, the societal interest in an adjudication on the merits increases with the seriousness of the offense. The result is that this factor is considered to be neutral. But I find it unacceptable to place value in the benefit derived by the accused from the exclusion of reliable evidence. The accused has a legitimate interest in having his or her rights protected, but not in having the evidence truncated to his or her advantage. In other words, the outcome of the analysis cannot be factored into the analysis itself. Moreover, the protection of the interests of the accused is considered in the first and second branches of the test proposed by the majority, not the third. The analysis to be conducted under Section 24(2) should not be more likely to result in the exclusion of evidence, where the charge is murder, than where it is theft. To the extent that the majority's approach has the effect of including in the third branch of the test factors related to the consequences of the charges for the accused, it is inconsistent with the analysis required at this stage. The suggestion that the effect of the factor of the seriousness of the offense is neutral because of the heightened societal interest in having a system of justice that is above reproach is also problematic. What might be criticized is the admission of evidence obtained in violation of constitutional rights. This implies that the violation is taken into account at this stage of the analysis. In other words, the violation will have been taken into account at every stage. At the first, in reviewing the conduct of the police. At the second, in assessing the impact of the violation on the protected interests. And lastly, at the third, in considering the interest in maintaining a system of justice that is above reproach. Furthermore, this approach evokes the broad concept of trial fairness, even though that concept is not formally included in the test proposed by the majority. Thus, trial fairness would be reintroduced indirectly, but in a more diffuse sense that is potentially much broader than the one in which it was used and the approach developed in Collins and Stillman. In my view, assessing the seriousness of the offense is as important as determining whether the evidence is reliable or essential. To disregard this factor would make as little sense as to disregard the fact that an accused who is granted a stay of proceedings will not be prosecuted. If the role of the courts is to conduct trials to seek the truth about the commission of crimes, the importance of this role reaches its apogee where the crime is a particularly serious one. I think it goes without saying that society has a greater interest in an adjudication on the merits where the crime is a serious one, such as murder, sexual assault, or importing hard drugs, than where it is less serious, as in the case of shoplifting, possession of cannabis, or assault. Subpart C. Proposed test. In short, I agree that the time has come for the court to revisit the test for the admission or exclusion of evidence obtained in violation of a charter right. I am proposing a simple test that takes into account both the public interest in protecting charter rights and the public interest in an adjudication on the merits. I agree with the majority that the judge's approach should be to foster the maintenance of public confidence in the administration of justice in the long term, but I would add that it is by striking a fair balance between these two societal interests that this result would be obtained. These are the only two aspects that a judge should consider in determining whether the maintenance of confidence in the administration of justice would be better served by admitting the evidence or by excluding it. On the branch related to the protection of constitutional rights, I would suggest that any facts that help show the effect of the violation on the protected rights be considered. In this respect, the state conduct that gave rise to the violation is obviously a relevant factor. However, the purpose of the judge's review is not to punish the police officers or to compensate the accused for the violation. Rather, it is to assess the impact of that conduct on the protected interests, with a view to ultimately balancing the societal interest in the protection of constitutional rights against the role of the judicial system as the institution responsible for holding trials. There may be cases in which conduct is so serious that the courts feel a need to disassociate themselves from it, and, in the end, to attach paramount importance to it in their analysis. In the test I am proposing, however, state conduct is but one of the factors to be considered in assessing the impact of violation on the protective rights. In the test I am proposing, however, state conduct is but one of the factors to be considered in assessing the impact of the violation on the protected rights. The impact of a violation on protected interests will vary with circumstances, and it would be impossible here to list all the circumstances that might be relevant. Suffice it to mention the place of the search, the nature of the evidence, the nature of the violated right, the urgency of the situation for the police officers, the availability of other less intrusive investigation methods, the officer's knowledge of the applicable law, their training, and the clarity of the law. In short, the judge must take into account all the facts that may be used to assess the long-term impact of his or her decision on the repute of the administration of justice. That is, not on the rights of the accused being tried, but rather on those of every individual whose rights might be violated in a similar way. As for the branch related to the public interest in an adjudication on the merits, I would suggest taking the reliability of the evidence into account. In my view, this consideration is crucial to the maintenance of public confidence. On the one hand, unreliable evidence will invariably undermine public confidence in the court's ability to determine whether the accused persons are guilty or innocent. On the other hand, a decision to exclude reliable evidence without good reason is also likely to be seen as an abdication by the court of its institutional role. As a corollary, whether the evidence in issue is essential or peripheral is highly significant. Similarly, the importance of the factor of the seriousness of the offense must be recognized, given society's strong interest in being protected from the commission of serious crimes. I have already explained why I feel this factor cannot reasonably be excluded without causing the test itself to bring the administration of justice into disrepute. This is why I would make it an important factor in the analysis. The question the judge must answer is whether the repute of the administration of justice would be better protected by admitting the evidence or by excluding it. In some cases, the impact on constitutional rights will be the determining factor because, owing to certain circumstances of the violation, the long-term effect of admitting the evidence would be to bring the administration of justice into disrepute. But the converse is also true. Thus, there will be other cases in which it is the public interest in an adjudication on the merits that should prevail. See, for example, the companion case of the Queen and Harrison. Absent an error in principle, the decision is a matter for the trier of fact. Part 3. Application of the principles to the facts of this case. On whether admitting the weapon in evidence would have a positive effect on the repute of the administration of justice, I agree with the majority's conclusion. I refer to the following findings of fact made by the trial judge. The exchange lasted only a few minutes, the officers were polite to Mr. Grant, and they were motivated by a desire to take a proactive approach in patrolling an area near schools with serious problems related to youth crime and safety. On the protection of the public, it should be noted that the charge here is firearms related, that it would be impossible to establish guilt without the evidence, and that the evidence is eminently reliable. When balanced against each other, the limited impact of the violation on the protected interests and the great importance of the evidence for the purposes of the trial favor admitting the physical evidence. Furthermore, on the charge of possession of a firearm for the purposes of trafficking, I am in complete agreement with the majority. For these reasons, I reach the same conclusion as the majority.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.